Record. Well, I'm delighted to say I'm joined by Stephen Heath Taylor, head of sports at the law firm JMW.
It's Stephen Taylor Heath, by the way, not Heath.
Stephen Taylor. I got it the wrong way around. I think on your email it's got Heath. Apologies. Look, jurisprudence being what it is, I'm glad we got it right. I've got to ask you, first of all, thank you very much for joining me. But you know, this has been a peculiar case, certainly from my perspective, to cover since last October, when these two tests, positive tests for clomiphene, became public knowledge in Conor Benn's build-up, if you like, to his cancelled fight, unsanctioned fight by the Boxing Board of Control with Chris Eubank last October the 8th. Without delving into the wheres and wherefores, we are at the point where Conor Benn defended his case to the World Boxing Council as part of their WBC Cares programme for one positive test, with what we have heard is a 270-page report. And we now understand that that report, as far as we understand, went to Ukad last month. And obviously a flurry of, say, revelations, but kind of information that's become public in the last week, Stephen, in the last 10 days, really, indicating that that report went to Ukad. Ukad have looked at it. Last March the 15th, last month, they revealed they provisionally suspended Conor Benn. And Conor Benn made public pronouncements after that. And then Ukad have also made a public announcement that they had charged him with that as well about 2.5 weeks ago. From lawyer speak, why has Conor Benn done this step right now, do you think?
Step in terms of the public statement that he's made?
Well, or even just taking his documentation to Ukad, to the Boxing Board of Control.
Well, I can't speak to the actual process that might have been adopted in relation to Conor Benn, but I can speak to Ukad's rules and regulations and procedures. No. And what they say is that Ukad can undertake an investigation, even in relation to matters that do not relate to testing that they've undertaken themselves, and that they can speak to stakeholders and the parties involved. In their procedures, they can issue a notice to somebody to say that they intend to charge them, and they can invite that person to make submissions to them. And then they might proceed to issue a formal charge notice. So if we look at where we are now, Ukad has confirmed that they have issued a formal charge notice. And the effect of that is that in some respects, it's now taken out of their hands because it goes to the anti-doping panel. And the anti-doping panel is independent of Ukad. It's set up by sports resolutions. And we're in the territory a little bit like the ECB with Michael Vaughan and the Premier League with Manchester City and Everton, in that there is an independent panel stroke tribunal set up to determine this matter. So Ukad effectively become the prosecutor and Conor Benn becomes the defendant. And Ukad, their default position is that everything has to be kept confidential and they won't make any statements. But they quite cannily, for want of a better expression, put in their regulations that if the other party make public statements and they think it's in best interest to make a public statement, then they will do so. So they will say that they're reacting to the statements that have been made in public by clarifying what the current position is, so that people are aware of the status of where we are. So obviously, in terms of the world governing body, they have their own clear boxing program, and VADA is part of that. Of course, back in October, we were talking about the fact that these tests were undertaken by VADA. They weren't undertaken by WADA. So the first thing that WADA will have to have established for themselves is that they can act in relation to a VADA test. If you look at the regulation that the boxer has been charged with, Regulation 2.2, that doesn't actually expressly refer to a sample, and it makes it clear that you don't have to establish negligence or intent to get over the threshold with regard to whether an offence has been occurred or not. Intent and negligence might be relevant to mitigation with regard to trying to reduce a ban that might be imposed. But as far as Ukad are concerned, by charging under that 2.2, in basic terms, it's effectively what Simon Jordan would call a strict liability offence. So that's where we are now, and Ukad have sought to establish what they have charged the boxer with, and also why they were making the public statement that they were with regard to where we are.
So in other words, they're saying we're going down the formal route. You had this in your body twice, clomiphene. So we're applying strict liability under that rule. So it's down to him now, presumably, in that hearing, that independent panel with the hearing, with him and his team as defence, and Ukad as prosecutor, as you say, almost like prosecutor, to prove to them in some form or another, if he wants to be found that it wasn't intentional, which might get him a 2-year ban, presumably. Obviously, it was, if they can, it's a 2-year or a 4-year ban, but can they reduce it less than that if they see that his defence has veracity?
Well, I think the relevant regulation is Regulation 10 in relation to Ukad regulations, and I believe that Regulation 10.6 provides that if you can provide sufficient mitigation, well, if there's no deliberate intent, then you immediately come down from 4 years to 2 years. But if you can show that you that there was no element of negligence in relation to how a substance has found its way into your system, then you can seek to reduce it below the 2 years. If you seek to go down that route, the other way you can go in relation to these types of cases under the regulations, and I'm not saying that that's what the advisors here might be considering, but you can avoid a full hearing if effectively you work with Ukad with regard to admitting the charges and effectively a plea bargain, for a better expression, with regard to what might be imposed, and also if you were to work with Ukad with regard to potentially pointing the finger at other people that might be involved. But as I say, I've no basis for saying that might apply here. If you are
there other cases like this? Have there been other cases with those?
Well, as I say, 99 times out of 100, these are all dealt with on a confidential basis. So you couldn't comment one way or another in relation to them. But you can say that that in terms of, if you are going to mount a robust defence, then I just reiterate that the National Anti-Doping Panel that will consider the charges is independent of Ukad. A chairman will appoint 2 panel members. Again, same type of tribunal procedure that you have in the Premier League dispute resolution chamber, and fairly universal across sport. Obviously, Sports Resolutions is a dispute resolution chamber in several sports. And so they will appoint a panel of 3. They will set the timetable and the procedures. If there's representations that this requires expert evidence, then they'll give provisions for the appointment of experts. Where you start adding layers to it, like experts and disclosure of documentation, in addition to written submissions, you do elongate the process. And so that can draw the process out. If effectively you've already prepared your submissions, then of course you can concertina the process, and you could, if for commercial reasons you want to have a swift resolution to this by by a particular date because you have a fight in mind or whatever, then you might seek to concertina the process so that you have it resolved by a particular date.
So in the event that what mystifies me is that if this, well, two things. The WBC found that eggs could have been the cause of it, even though Ben has denied, rightly or wrongly, that it could have been caused by eggs. Could a defence such as that, where they have found a surfeit of eggs in his nutritional diet, could have caused it, would that be a case that if you were representing that person, you would put forward or not?
Well, you're not necessarily comparing eggs with that sort of type of situation, because if you are looking at a separate set of rules and regulations, then, you know, for example, Gareth, obviously a state athletic commission in America, for example, might have a different threshold with regard to what's regarded as acceptable and compared to a local governing body, for example. So you have to look at what the rules and regulations are, and you have to look at what the offence is and the charge in relation to the offence. So if you look at that charge under 2.2, as I say, it doesn't require proof of negligence or intent in order to establish whether an offence has occurred. It relates to the prohibited substance and the result of the test. If
but
that's
he's challenging the veracity of the tests as well. So could that be part of the case as well? If they bring...
I think that in theory that could definitely be part of it.
Is this new ground? Is this new ground, or has this been done before in certain cases?
It's new ground insofar as that WADA are acting on tests that were undertaken by a separate testing body. I mean, VADA make a play of saying that they're not a signatory to the WADA rules and regulations. VADA are a commercial entity that undertakes testing. It's separate to WADA, and VADA are not commissioned by WADA to undertake testing on their behalf. So it is uncharted territory in that regard. So in order for WADA to satisfy themselves that that they can act on this test, then you start looking at definitions such as adverse analytical findings. And if you look at that, that relates to a finding of a sample by a laboratory that's approved by WADA. So you start looking at things like that. So it is uncharted territory in relation to that, because you would normally expect that WADA would be taking action in relation to a test that they've undertaken. And if you are the lawyers representing the boxer, who are extremely good lawyers, then they will be looking at everything. But you can't necessarily compare, and you can't necessarily say that if there is a finding by a boxing world governing body, that how can that governing body find in one particular way when the National Anti-Doping Panel might find in a different way? They might have found in a different way because of the nature of the regulation that the boxer is charged with, not necessarily that they've interpreted the facts in a different way. It's just that the offence, as it were, for want of a better expression, may be an entirely different type of offence.
What are the ramifications, in your view, of a hearing for Ben and him fighting abroad? Can he... What's the situation? Do UKAD, in their rules and regulations of Boxing Board of Control, have jurisdiction over stopping a fighter boxing abroad if they have an opportunity under a different sanctioning body?
I think it's a different issue. The Boxing Board of Control have commissioned WADA to undertake their doping control program and testing for the British Boxing Board of Control, and as WADA do for many sports and many governing bodies. So if it's an organisation that is sanctioning a boxing bout overseas, and their testing is undertaken by WADA, you would have thought that the imposition of a ban would automatically apply there.
Or even a provisional suspension. Yeah.
Well, yeah, a provisional suspension is an interim step that is taken to preserve the status quo, so that pending a final resolution, that particular athlete is not able to compete, on the basis that, on the balance, it's regarded as fairer and in the best interests of everybody concerned that athlete is not allowed to compete. You can challenge an interim order, so you can seek to have that removed as part of the proceedings.
So he could. So what I'm asking is simply is, if he's got an opportunity to work at the moment abroad that's created for him, let's say by his promoter Eddie Hearn, if he's not threatened by the Boxing Board of Control and so on, you know the outlay of this, that it could affect the person he boxes, the promoter's license in this jurisdiction. So what I'm kind of asking is, and I know there are lots of ramifications to all of these things, because it's one of the most complex cases we've seen for a long time, certainly in boxing, because the way it's been guided, if you like, and the direction it's gone in, there is an out. So there is a way of him then fighting and earning during this hearing.
Yeah, if you, again, obviously you work in other sports as well, and what have you. If you look at, for example, the situation with the golfers in the DP Tour, for example, there was a final ruling in relation to that, which said that the golfers couldn't take part in DP World Tour golf events. But in the interim, whilst this case was going on, they were allowed to take part in those events, because
otherwise, is it restraint of trade or restraint?
Yeah. So pending the final outcome, they were allowed to earn a living. Now, as it's turned out, because of that ruling, they're not allowed to take part in the events that they took part in the intervening period. But so if you are representing a boxer that is under an interim suspension, then you might make similar arguments, and bearing in mind that this is being dealt with by Sports Resolutions, who also dealt with that case as well, then you may make submissions as to why it's reasonable in the current circumstances to allow that professional sports person to earn a living pending the final outcome. The counter argument would obviously might be argued that, given the nature of the proceedings and what have you, that it's overall the interim suspension should remain. But that would be the counter argument that would be raised probably on behalf of Ukad. So so you have two situations. You either have that this is resolved one way or another. Well, you have three situations. You either have a situation where it's resolved one way or another by a date in the future that the boxer was intending to fight, or you have the lifting of an interim suspension, which enables the boxer to fight, or you have a situation where these proceedings are ongoing and an event takes place that is regarded as outside the jurisdiction of the interim suspension. And obviously then you have issues, as has been commented, with regard to the relevant parties being involved, being licensed by local boxing councils, and the terms of their license, and issues of whether boxing is being brought into disrepute and the like.
Do you think, overall, in your experience of these things, this is an important test case for boxing, maybe, or for sport in general? I know there have been cases in America before where, I think in baseball, one of my colleagues in America, one of my friends in America, Chris Mannix, who covers baseball and basketball and boxing, has said that there have been cases like this in the past in America where athletes have just said point blank, I didn't take anything. I just did not take anything. I don't know how it got there. And in the end, they do go back to the sport. Is this a test case? Is this are the bounds of loopholes and where we're at with it I must say, during this interview, Conor Benn has said at all points that he is not a guilty man. He never ever took anything, to give him his due. I never ever took anything illegal. I never knowingly taken. I'm not a cheat. So I think I need to say that during the course of this interview. So, is it an important test case? Are the bounds being stretched? Are we looking at it like this because of what happened last October, where for 30 hours the fight was still on and no one could even believe it, even though the Boxing Board of Control weren't going to sanction it?
Yeah, it's important in many respects. It's one of those where, and you're absolutely right, obviously, is to say, is with regard to the position that Conor Benn has taken throughout this, and as you say, this has become quite protracted, bearing in mind that these events occurred in October last year, and Conor Benn has not been able to box in the intervening period, and we've just discussed the possibility of an interim suspension being lifted and what have you. But you may say that some lessons might potentially be learned from this, but on the basis that there are more than one organisation undertaking testing. There is naturally, obviously, more than one regulatory body that's relevant to this, with differing rules and regulations. And there perhaps needs to be an element of uniformity in relation to something as important as doping. Yeah. And if there is more of an element of uniformity
in a sport like boxing, particularly, where it is your body is your weapon.
And so that, you know, if you are banned by somebody, you shouldn't necessarily be able to therefore to fight in a different jurisdiction or under a different regulatory body and what have you. And so that there, and if you do have that element of certainty, then of course it makes everything a little bit easier for everybody involved. So it's easier to understand what regime is involved. Lawyers make money from from discrepancies in rules and regulations. If there's clarity as to where everybody stands, then it may, as I say, concertina some of the processes and allow things to be dealt with more quickly and arguably more openly, because you spend less time arguing about whether there are grounds for taking action in particular circumstances. But of course, doping is an issue across several athletic sports and what have you, and WADA undertake testing, and their rules and regulations apply to various different professional sports, and obviously there are nuances to different professional sports, and the Boxing Board of Control undertake their testing through WADA, and WADA came in to do testing mainly in relation to boxing. So again, the fact that promoters and what have you felt the need to include WADA testing and not just use WADA testing, these are the type of issues that probably need to be looked at in the round. So it's a test case in relation to the procedures, but it's also a test case as to why there are so many grey areas.
So what you're saying is, in short, that this case, perhaps due to the high profile nature of the boxer, the amount of money that could have been earned from the event, how big it was nationally, has just exposed, in a sense, the failings of a system that maybe isn't still sufficiently watertight to be able to make decisions with clarity without the confusion that's gone on over the last 6-7 months.
Yeah, but we both know, Gareth, obviously, there's people that are involved in boxing. You've got athletic commissions, you've got governing bodies, you've got world governing bodies, of course, and you've got professional boxers that are sole traders. But there are several elements of the sport of boxing that are quite unique. And as I say,
ungovernable. Is it lawless? We often talk about fight sports being lawless. or boxing being lawless at times. I don't mean that literally, but there are times when it feels like it's the Wild West. You
I
know,
hope it's not literally, otherwise I'd be redundant. But I think it's what I'm talking about here is that that you know, you need to kind of like join the dots, and you've got wider rules and regulations. I mean, the fact that you're talking to me about these rules and regulations, where we've got to now is that this particular case is being dealt with by the National Anti-Doping Panel, which, as I say, is an independent panel, which is going to determine this particular matter, and that's where we've got to. It's an argument and a debate across several sports with regard to whether there should be an independent regulator, you know, whether that independent regulator should regulate across the board, you know, not just football and what have you. So you know, you wonder to yourself if there was like one set of regulations and what have you, and there was more of a collaboration with regard to the rules and regulations. So there's a consistency between the rules and regulations. Then, of course, you minimise the discrepancies that could occur.
bottom line now, then, how do we do this? And was Ben perhaps? I don't want to ask whether another legal team has advised him wrongly, but my understanding is that even though this case came to, well, not the case, but the situation came to light last October, it's only from the point where he's provisionally suspended that the suspension, either 2 years or 4 years or nothing or whatever it's going to be, after they've had this hearing, however long it takes for the panel to hear all this and have the evidence, that the dealing is from that point, March the 15th, not back to October last year, when he or when he surrendered his license last year, which was, I think, December. I think it was early December, I think.
Yeah, I'm not sure I could answer that, because I think that relates to the specifics of the case, which I don't think we should speculate on, and certainly wouldn't speculate on the advice that he's received. I think that you know, in terms of what a boxer does, obviously, you know, he has felt the need to speak in public and go on Piers Morgan and things like that, and he clearly feels that the need to do that.
Did that do him any good, going on Piers Morgan, in your view, legally?
Well, as I say, that if you look at the Ukad statement, the Ukad are saying we would not have made a public statement had it not been for the public statements that we've seen from the boxer.
Yeah.
So make of that what you will. But as I say, he
only responded to it being leaked in the papers, or by a I think it was Boxing News. He responded to that story going out in Boxing News, didn't he? So,
well, if I was the lawyers in relation to that, then I'd probably be looking at where the leaks come from, as to whether that's an invasion of somebody's privacy. But you know, that, as I say, once you make a public statement yourself, then if you look at the way that you kind of framed their rules say that if there is a public statement made by somebody involved in the matter, we reserve the right to make our own public statement, which is what they've done.
Yeah, but we can get into the whole realms of social media there, and how people make public statements about everything everywhere now. I mean, you know, it's a mess, isn't it? All of it, really. Because you know, it's people make pronouncements about other people. Conor Benn's being pilloried by people in the public. They don't know any of the details in the background. So I think he's just being human, isn't he, in lots of ways, by responding, you know?
Well, yeah, and also
he's like a human being rather than a case. I mean, he's a 26-year-old man, you know, whether he's done right or wrong, you know, in this. And you know, I mean, I've seen him once. He was upset with me. You know, all I've done is my job. I've never actually accused him of being a cheat, because I don't know that he is. I know that he had this thing in his system twice.
Well, listen, I mean, let's be very, very clear. Nobody can, if you look at the defamation rules and what have you, and serious harm to people and things like that, arguably the defamation, it's a discussion for another time, but arguably the defamation rules and what have you are totally out of pace now with social media. And the fact that these companies that run the main social media sites have their own attitudes to what's acceptable and what's not acceptable, and that's not on all fours with our defamation rules and regulations, that people therefore might think to themselves, well, the law's not going to protect me, so why should I comply with the law? Yeah. So when you're talking about playing things out in public in that regard, but we must certainly respect the process as to where it is. And as I say, we are no further forward than the statement that the National Anti-Doping Panel is being convened to consider these charges that have been brought. And so it would be wrong to go any further than that at this stage.
Well, we won't go any further than that at this stage. An absolute pleasure to speak to you, Stephen. I see this, we could probably talk about this for hours, you and I. But let's call this stage one of about 7 or 8 then, yeah? a regular weekly or fortnightly catch up.
All right, well, just send me a weekly reminder. I'll put it in my diary.
Okay, brilliant. Thank you.
All right, cheers. Take care.